Hello, and welcome to our second tutorial key point video. Started off, obviously, by looking at the first TMA. Key points I would make is do look at those marking bands. I have to mark by the criteria in those bands, so look at those when you're aiming to get to a particular band. Introductions are, I am afraid, a costly luxury in these very tightly word-limited TMAs. So cut straight to the point in all your answers. The importance of definitions, very important for lawyers. It's also important to note that some words have different meanings in different contexts. Civil law, common law, civil law. And one way that you might want to address this is actually making small tables which show the different meanings, particularly important in the different meanings of civil law. Can also apply to common law, although outside the TMA, but it's useful that you understand that there are very different meanings and you can only tell from the context which meaning applies. Do have a look at answering problem questions, and I've sent some feedback notes which are now available to you. One thing for exam purposes, make sure you know all the differences between criminal and civil law. And again, it might be handy to build up a table showing civil and criminal and doing the compare and contrast. So, you know, civil law, the burden of proof, the standard of proof is balance of probabilities, whereas with criminal law it is beyond reasonable doubt. We moved on to that, I said a few words about research and problem analysis. Do have a look at the manual, page 97. It's a very, very useful tool. Take that approach and you'll find that solving legal problems is much easier. The issues for this tutorial really were the raw materials of law, statutes and law reports. So we looked first at statutory interpretation. And what I want you to be thinking about is what are the problems in discerning Parliament's wills? Do judges make law? And a slightly different question, should judges make law? The tools for an interpretation look at the rules of construction, the rules of language, aids to interpretation and presumptions. Again, it's a very frequent exam question asking you to outline each of those. Then we moved on to judicial precedent and how it works in practice. Again, look at the basic rules and the tools. Also consider when a previous decision isn't followed, how do the courts do it? And the best way actually of seeing this is going to a court, the Supreme Court, Court of Appeal to a lesser extent, because you actually see the two sides arguing the different precedents. One saying these precedents should be followed, the other saying this should be distinguished for these reasons. English legal system, make sure that you know the structure of the courts, who's who within the courts. Don't bother with details like what colour judges wear at different times of the year, but be able to talk about judges, barristers and solicitors. But the key area to look at is lay personnel within the legal profession. And this is something, again, very popular for exam questions. You know, the role of juries, the role of magistrates. So do look at those two topics in detail and be able to argue the advantages and disadvantages for each of them. Then we moved on to principles of UK constitutional law, and there are four key areas to look at. Separation of powers. Look at where the idea came from and how it has developed over in time. It started as a way of analysing the different functions of government, you know, making laws, carrying them out, judging on them. and how in the 17th and 18th century the emphasis gets put on making sure that the same people aren't in different branches. A pure system like the United States, where there's a very strict separation of powers, consider how much separation of powers there are in the British system, and there is a lot. But also look at that other constitutional principle, the idea of ministerial responsibility, where ministers are responsible before Parliament, which does, and means the members of. So there is some blurring there. Parliamentary sovereignty, Dicey is a wonderful structure to use. He talks about sovereignty of Parliament meaning having three different aspects. Parliament can pass any law it wants, a contrast with the US Congress, where the Supreme Court can strike down laws which are unconstitutional. No parliament is bound by its predecessors, which means that we can't have entrenched legislation, special procedures to change the law. Parliament, with an ordinary act of Parliament, can change the constitutional rules. And thirdly, no court can question what Parliament has done. And in your reading, consider how our membership of the European Union and our separate membership of the signing up to the European Convention on Human Rights has on that doctrine. We finished off by looking at TMA02. You will see that you are asked to explain and discuss the extent to which you agree with a statement. The marks are not so much in describing and explaining, but in that critical evaluation of the arguments. I don't want you to describe the arguments. I want you to make out the arguments, looking at their strengths and their weaknesses, and coming to a reasoned conclusion. And I don't mind what that conclusion is. That's not important. It's the way that you use your thinking skills and your arguing skills to come to a reasoned decision. So I don't want any answers which just look at one side of the argument. Again, question 2, explain and evaluate. This will be key between the pass and the highest marks. So analyse the statement. Look at juries in criminal cases, not civil cases. The numbers and significance. Look at qualifications, ineligibility, challenges, but at the heart of it, the advantages and the disadvantages. Well, with that, I'll finish. Have a good Christmas, and I look forward to seeing you in the new year.